Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legalistening, where you can unlock some fun bonus content with me, Zack, and some special guests. Thanks so much for all your support. Hey, welcome to Legal Listening, where audio Obiter is our thing. We're Carly and Zack, and we're so glad you're here with us today. Today on the podcast, we have the Queen and Kapp, which is going to fit in with our, I must say, robust section of Section 15 cases, constitutional cases. This one's a little different because we both have, it's a mixture. It's an Aboriginal law case, and it's also a constitutional Section 15 case. And it's also really important because it's a little different from all the other ones we've done, because this isn't dealing with Section 15.1. This is primarily dealing with Section 15.2 and how the two sections fit together. So what do you remember about this one, Zack?
So I remember taking this, I'm sure we covered it in constitutional law, but like what else was 1,000 years ago? I also remember covering it, though, in Aboriginal law and society, which we dealt with it not from the charter angle, but as a matter of Aboriginal rights and how they intersect with the charter necessarily. So I think it's a great example of just how these two types of law come together. I don't want to say in conflict because that's not right. It's fascinating to me how you can have both Aboriginal rights, which are this legal construction, and then the charter as a legal construction in terms of the equality sections. Yeah. And that's why I think this case does really well as like a 15 case, because I think it covers off both of those pretty well. And it's just, it's so interesting. There's so much to learn about 15. I know. Now the intersection of, like I said, the legal definition of what Aboriginal rights are, because like that's a fake thing that exists as like a legal construction.
Yeah, no,
they use, that's the language that the charter uses.
Yeah, no, I love Section 15, and I find it like, I don't know, it gets overlooked a lot in constitutional stuff because people want to talk about like Section 7 and Section 2B and like all the things that like you couldn't pay me to take a class on freedom of expression. No, thank you. I'm not confrontational enough for that. But this was always my favorite. And I love this case because it essentially says, so, 15.2 is our ameliorative program provision. So we say, the Constitution says, if, a group or whatever has been historically discriminated against, you can have programs that put them, try to, to rectify a historic disadvantage. And that's exactly what this is doing. It's granting specific fishing licenses to Aboriginal people in the Fraser River area. And people who are not Aboriginal were challenging it as unfair under 15.1. And the court said, at the Supreme Court, they said, no, you can't do that. 15.1 and 15.2, they work together. Affirmative action, if we want to use the U.S. way of saying it, affirmative action programs are perfectly constitutional in Canada as long as they are being used as designed to essentially not correct, but to rectify a historic disadvantage or discrimination that is perfectly acceptable. And the court's language is pretty strong, and they say, no, like this is allowed here. This is not prohibited. You cannot challenge this in a constitutional way because both sections work together. 15.1 and 15.2 have to be read as a whole.
Yeah, exactly. And I think, like I said, when coming back from like the Aboriginal law angle, it gets into the importance of Indigenous communities and their ability to uphold their traditional ways of life and values in such a way that obviously they don't necessarily fit within the normal confines of what I'll call like the fishing season. And so, like I said, it's interesting to see the charter being used in an affirmative action way, using that American terminology to kind of, I guess it feels like balancing the scales in a sense is what it's trying to do. Whether that's right or wrong is obviously a whole other issue. Yeah. And, discussing whether the charter is even an appropriate mechanism for Indigenous people is, again, fairly disputable. And I think there's a lot of good arguments on both sides for it. But it's always interesting to see how these cases are brought up because a very hot topic is affirmative action.
Yeah.
And Facebook comments love talking about it.
Oh, my God. Hide your grandmas from the computer. Yeah, but I mean, it's especially topical because Kapp is I think '08, I believe '09, and I mean we literally just had the issue with the Micmac fisheries out east this past fall, and white settlers who are living on Micmac land feeling that any sort of ameliorative program which gives them personal fishing license is somehow unfair. So it's definitely still topical, that's for sure. This case is over 13 years old almost now, and these issues are still happening today, right now, in Canada. And I don't know, I find it definitely sort of required reading / listening for anybody who tries to make, arguments against programs like this that are designed to rectify harm done by the government historically against Indigenous people. So it's definitely an interesting one. It's a little, keeping in line with our excellent production of Section 15 cases, but it's different because it talks about 15.2. So it's definitely an excellent listen. It's a very engaging case, and we hope you guys enjoy. The Queen and Kapp, Supreme Court of Canada. Heard December 11th, 2007 and June 27th, 2008. On appeal from the Court of Appeal for British Columbia. The judgment of Chief Justice McLaughlin and Justices Binney, Labelle, Deschamps, Fish, Abella, Charon, and Rothstein was delivered by the Chief Justice and Justice Abella. Part A. Introduction. The appellants are commercial fishers, mainly non-Aboriginals, who assert that their equality rights under Section 15 of the Canadian Charter of Rights and Freedoms were violated by a communal fishing license granting members of 3 Aboriginal bands the exclusive right to fish for salmon in the mouth of the Fraser River for a period of 24 hours on August 19th to 20th, 1998. The appellants base their claim on Section 15.1. The essence of the claim is that the communal fishing license discriminated against them on the basis of race. The Crown argues that the general purpose of the program under which the license was issued was to regulate the fishery, and that it ameliorated the conditions of a disadvantaged group. These contentions, taken together, raise the issue of the interplay between Section 15.1 and Section 15.2 of the Charter. Specifically, they require this court to consider whether Section 15.2 is capable of operating independently of Section 15.1 to protect ameliorative programs from the claims of discrimination, a possibility left open in this court's equality jurisprudence. We have concluded that where a program makes a distinction on one of the grounds enumerated under Section 15 or an analogous ground, but has at its object the amelioration of the conditions of a disadvantaged group, Section 15's guarantee of substantive equality is furthered, and the claim of discrimination must fail. As the communal fishing license challenged in this appeal falls within Section 15.2's ambit, one of its objects being to ameliorate the conditions of the participating Aboriginal bands, the appellant's claim of a violation of Section 15 cannot succeed. While the operation of Section 15.2 is sufficient to dispose of the appeal, in addition to examining the respective roles of Section 15.1 and Section 15.2, we'll comment briefly on Section 25 of the Charter in view of the reasons of Justice Bastarache on this point. Part B. Factual and Judicial History. Prior to European contact, Aboriginal groups living in the region of the mouth of the Fraser River fished the river for food, social, and ceremonial purposes. It is no exaggeration to say that their life centered in large part around the river and its abundant fishery. In the last 2 decades, court decisions have confirmed that pre-contact fishing practices integral to the culture of Aboriginal people translate into a modern-day right to fish for food, social, and ceremonial purposes. The right is a communal right. It inheres in the community, not the individual, and may be exercised by people who are linked to the ancestral Aboriginal community. The Aboriginal right has not been recognized by the courts as extending to fishing for the purpose of sale or commercial fishing. The participation of Aboriginals in the commercial fishery was thus left to individual initiative or to negotiation between the Aboriginal peoples and the government. The federal government determined that Aboriginal people should be given a stake in the commercial fishery. The bands tended to be disadvantaged economically compared to non-Aboriginals. Catching fish for their own tables and ceremonies left many needs unmet. The government's decision to enhance Aboriginal involvement in the commercial fishery followed the recommendations of the 1982 Pearce Final Report, which endorsed the negotiation of Aboriginal fishery agreements. The Pearce Report recognized the problematic connection between Aboriginal communities' economic disadvantage and the long-standing prohibition against selling fish, a prohibition that disrupted what was once an important economic opportunity for Aboriginals. Policing the prohibition was also problematic. The 1994 Gardner-Pinfold Report addressed the serious conservation issue stemming from a fish sales prohibition honored more in the breach than the observance. The decision to enhance Aboriginal participation in the commercial fishery may also be seen as a response to the directive of this court in Sparrow, that the government consult with Aboriginal groups in the implementation of fishery regulation in order to honor its fiduciary duty to Aboriginal communities. Subsequent decisions have affirmed the duty to consult and accommodate Aboriginal communities with respect to resource development and conservation. It is a constitutional duty, the fulfillment of which is consistent with the honor of the Crown. The federal government's policies, aimed at giving Aboriginal people a share of the commercial fishery, took different forms, united under the umbrella of the Aboriginal Fisheries Strategy. Introduced in 1992, the Aboriginal Fisheries Strategy has 3 stated objectives: ensuring the rights recognized by the Sparrow decision are respected, providing Aboriginal communities with a larger role in fisheries management and increased economic benefits, and minimizing the disruption of non-Aboriginal fisheries. In response to consultations with stakeholders carried out since its inception, the Aboriginal Fisheries Strategy has been reviewed and adjusted periodically in order to achieve these goals. A significant part of the Aboriginal Fisheries Strategy was the introduction of 3 pilot sales programs, one of which resulted in the issuance of the communal fishing license at issue in this case. The license was granted pursuant to the Aboriginal Communal Fishing Licenses Regulations, SOR-93-322, the ACFLR. The ACFLR grants communal licenses to Aboriginal organizations, defined as including, quote, an Indian Band Council, a tribal council, and an organization that represents a territorially based Aboriginal community, end quote. The communal license cannot be granted to individuals, but an Aboriginal organization can designate its use to individuals. The license with which we are concerned permitted fishers designated by the bands to fish for sockeye salmon between 7 a.m. on August 19, 1998, and 7 a.m. on August 20, 1998, and to use the fish caught for food, social and ceremonial purposes, and for sale. Some of the fishers designated by the bands to fish under the communal fishing license were also licensed commercial fishers entitled to fish at other openings for commercial fishers. The appellants are all commercial fishers who were excluded from the fishery during the 24 hours allocated to the Aboriginal fishery under the communal fishing license. Under the auspices of the BC Fisheries Survival Coalition, they participated in a protest fishery during the prohibited period for the purpose of bringing a constitutional challenge to the communal license. As anticipated, they were charged with fishing at a prohibited time. In defense of the charges, they filed notice of a constitutional question seeking declarations that the communal fishing license, the ACFLR, and related regulations and the Aboriginal Fishery strategy were unconstitutional. The Provincial Court of British Columbia, Judge Kitchen, found that the communal fishing license granted to the three bands was a breach of the equality rights of the appellants under Section 15.1 of the Charter that was not justified under Section 1 of the Charter. The court stayed proceedings on all the charges under Section 24 of the Charter. The Supreme Court of British Columbia, Chief Justice of the Supreme Court Brenner, allowed a summary convictions appeal by the Crown. It held that the pilot sales program did not have a discriminatory purpose or effect because it did not perpetuate or promote the view that those who were forbidden to fish on the days when the pilot sales program fishery was open are less capable or worthy of recognition or value as human beings or as members of Canadian society. Justice Brenner lifted the stay of proceedings and entered convictions against the appellants. The British Columbia Court of Appeal, in 5 sets of reasons concurring in the result, dismissed the appeal. Appeal Justice Lowe concluded that the pilot sales program did not constitute denial of a benefit under Section 15 when the matter was viewed in a contextual rather than formalistic way. Appeal Justice Mackenzie rejected the claim of discrimination on the basis that a discriminatory purpose or effect had not been established, endorsing the view of Justice Brenner on the summary convictions appeal. Appeal Justice Kirkpatrick dismissed the Section 15 claim on the basis that Section 25 of the Charter, which protects rights and freedoms pertaining to the Aboriginal peoples of Canada, insulated the scheme from the discrimination charge. Chief Justice Finch concurred with both Appeal Justice Lowe and Appeal Justice Mackenzie on the Section 15 issue and found that Section 25 was not engaged. Finally, Appeal Justice Levine agreed with Justice Finch on the Section 15 issue, but declined to express a view on whether Section 25 was engaged. Part C. Analysis. Section 15 of the Charter provides 15.1. Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Sub 2. Subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Subpart 1. The purpose of Section 15. Nearly 20 years have passed since the court handed down its first Section 15 decision in the case of Andrews and Law Society of British Columbia. Andrews set the template for this court's commitment to substantive equality, a template which subsequent decisions have enriched but never abandoned. Substantive equality, as contrasted with formal equality, is grounded in the idea that, quote, the promotion of equality entails the promotion of a society in which all are secure in the knowledge that they are recognized at law as human beings equally deserving of concern, respect, and consideration, end quote. Andrews, at page 171 per Justice McIntyre for the majority on the Section 15 issue. Pointing out that the concept of equality does not necessarily mean identical treatment, and that the formal like treatment model of discrimination may in fact produce inequality, Justice McIntyre stated, quote, to approach the ideal of full equality before and under the law, and in human affairs, an approach is all that can be expected. The main consideration must be the impact of the law on the individual or the group concerned. Recognizing that there will always be an infinite variety of personal characteristics, capacities, entitlements, and merits among those subject to a law, there must be accorded, as nearly as many be possible, an equality of benefit and protection, and no more of the restrictions, penalties, or burdens imposed upon one than another. In other words, the admittedly unattainable ideal should be that a law expressed to bind all should not, because of irrelevant personal differences, have a more burdensome or less beneficial impact on one than another." End quote. While acknowledging that equality is an inherently comparative concept, Justice McIntyre warned against a sterile, similarly situated test focused on treating likes alike. An insistence on substantive equality has remained central to the court's approach to equality claims. Sections 15.1 and 15.2 work together to promote the vision of substantive equality that underlines Section 15 as a whole. Section 15.1 is aimed at preventing discriminatory distinctions that impact adversely on members of groups identified by the grounds enumerated in Section 15 and analogous grounds. This is one way of combating discrimination. However, governments may also wish to combat discrimination by developing programs aimed at helping disadvantaged groups improve their situation. Through Section 15.2, the Charter preserves the right of governments to implement such programs without fear of challenge under Section 15.1. This is made apparent by the existence of Section 15.2. Thus, Section 15.1 and Section 15.2 work together to confirm Section 15's purpose of furthering substantive equality. The template in Andrews, as further developed in a series of cases accumulating in Law in Canada, Minister of Employment and Immigration, established in essence a two-part test for showing discrimination under Section 15.1. 1. Does the law create a distinction based on an enumerated or analogous ground? 2. Does the distinction create a disadvantage by perpetuating prejudice or stereotyping? These were divided in law into 3 steps, but in our view the test is, in substance, the same. In Andrews, Justice McIntyre viewed discriminatory impact through the lens of 2 concepts. 1. The perpetuation of prejudice or disadvantage to members of a group on the basis of personal characteristics identified in the enumerated and analogous grounds. And 2. Stereotyping on the basis of these grounds that results in a decision that does not correspond to a claimant or group's actual circumstances and characteristics. Andrews, for example, was decided on the second of these concepts. It was held that the prohibition against non-citizens practicing law was based on a stereotype that non-citizens could not properly discharge the responsibilities of a lawyer in British Columbia, a view that denied non-citizens a privilege, not on the basis of their merits and capabilities, but on the basis of what the Royal Commission report on equality in employment referred to as, quote, attributed rather than actual characteristics, end quote. Additionally, Justice McIntyre emphasized that a finding of discrimination might be grounded in the fact that the impact of a particular law or program was to perpetuate the disadvantage of a group defined by enumerated or analogous grounds. In this context, he said, quote, I would say then that discrimination may be described as a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society, end quote. A decade later, in law, this court suggested that discrimination should be defined in terms of the impact of the law or program on the human dignity of members of the claimant group, having regard to 4 contextual factors. 1. Pre-existing disadvantage, if any, of the claimant group. 2. Degree of correspondence between the differential treatment and the claimant group's reality. 3. Whether the law or program has an ameliorative purpose or effect. And 4. The nature of the interest affected. The achievement of law was its success in unifying what had become, since Andrews, a division in this court's approach to Section 15. Law, accompanied by reiterating and confirming Andrew's interpretation of Section 15 as a guarantee of substantive and not just formal equality. Law accompanied this by reiterating and confirming Andrew's interpretation of Section 15 as a guarantee of substantive and not just formal equality. Moreover, Law made an important contribution to our understanding of the conceptual underpinnings of substantive equality. At the same time, several difficulties have arisen from the attempt in law to employ human dignity as a legal test. There can be no doubt that human dignity is an essential value underlying the Section 15 equality guarantee. In fact, the protection of all of the rights guaranteed by the Charter has as its lodestar the promotion of human dignity. As Chief Justice Dixon said in The Queen and Oaks, quote, "The court must be guided by the values and principles essential to a free and democratic society, which I believe embody, to name but a few, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions which enhance the participation of individuals and groups in society." End quote. But as critics have pointed out, human dignity is an abstract and subjective notion that, even with the guidance of the four contextual factors, cannot only become confusing and difficult to apply, it has also proven to be an additional burden on equality claimants, rather than the philosophical enhancement it was intended to be. Criticism has also accrued for the way law has allowed the formalism of some of the court's post-Andrews jurisprudence to resurface in the form of an artificial comparator analysis focused on treating likes alike. The analysis in a particular case, as law itself recognizes, more usefully focuses on the factors that identify impact amounting to discrimination. The four factors cited in law are based on and relate to the identification in Andrews of perpetuation of disadvantage and stereotyping as the primary indicators of discrimination. Pre-existing disadvantage and the nature of the interest affected, factors 1 and 4 in law, go to perpetuation of disadvantage and prejudice, while the second factor deals with stereotyping. The ameliorative purpose or effect of a law or program, the third factor in law, goes to whether the purpose is remedial within the meaning of Section 15.2. We would suggest, without deciding here, that the third law factor might also be relevant to the question under Section 15.1, as to whether the effect of the law or program is to perpetuate disadvantage. Viewed in this way, law does not impose a new and distinctive test for discrimination, but rather affirms the approach to substantive equality under Section 15 set out in Andrews and developed in numerous subsequent decisions. The factors cited in law should not be read literally as if they were legislative dispositions, but as a way of focusing on the central concern of Section 15 identified in Andrews: combating discrimination, defined in terms of perpetuating disadvantage and stereotyping. The central purpose of combating discrimination, as discussed, underlies both Section 15.1 and Section 15.2. Under Section 15.1, the focus is on preventing governments from making distinctions based on the enumerated or analogous grounds that, having the effect of perpetuating group disadvantage and prejudice, or impose disadvantage on the basis of stereotyping. Under Section 15.2, the focus is on enabling governments to proactively combat existing discrimination through affirmative measures. Against this backdrop, we turn to a more detailed examination of Section 15.2 and its role in this appeal. Part 2, Section 15.2. Under Andrews, as previously noted, Section 15 does not mean identical treatment. Justice McIntyre explained that, quote, "every difference in treatment between individuals under the law will not necessarily result in inequality, and that identical treatment may frequently produce serious inequality," end quote. Justice McIntyre explicitly rejected identical treatment as a charter objective, based in part on the existence of Section 15.2. At page 171, he stated that, quote, "The fact that identical treatment may frequently produce serious inequality is recognized in Section 15.2, end quote. Rather than requiring identical treatment for everyone, in Andrews, Justice McIntyre distinguished between difference and discrimination and adopted an approach to equality that acknowledged and accommodated differences. Justice McIntyre proposed the following model at page 182. Quote, "In assessing whether a complainant's rights have been infringed under Section 15.1, it is not enough to focus only on the alleged ground of discrimination and decide whether or not it is an enumerated or analogous ground. The effect of the impugned distinction or classification on the complainant must be considered. Once it is accepted that not all distinctions and differentiations created by law are discriminatory, then a role must be assigned to Section 15.1, which goes beyond the mere recognition of a legal distinction. A complainant under Section 15.1 must show not only that he or she is not receiving equal treatment before and under the law, or that the law has a differential impact on him or her in the protection or benefit accorded by law, but, in addition, must show that the legislative impact of the law is discriminatory, end quote. In other words, not every distinction is discriminatory. By their very nature, programs designed to ameliorate the disadvantage of one group will inevitably exclude individuals from other groups. This does not necessarily make them either unconstitutional or, quote, reverse discrimination. Andrews requires that discriminatory conduct entail more than different treatment. As Justice McIntyre declared at page 167, a law will not necessarily be bad because it makes distinctions. In our view, the appellants have established that they were treated differently based on an enumerated ground, race. Because the government argues that the program ameliorated the conditions of a disadvantaged group, we must take a more detailed look at Section 15.2. The question that arises is whether the program that targeted the Aboriginal bands falls under Section 15.2 in the sense that it is a law, program, or activity that has as its object the amelioration of conditions or disadvantaged individuals or groups. As noted, the communal fishing license authorizing the 3 bands to fish for sale on August 19th to 20th was issued pursuant to an enabling statute and regulations, namely the ACF-LR. This qualifies as a law, program, or activity within the meaning of Section 15.2. The more complex issue is whether the program fulfills the remaining criteria of Section 15.2. That is, whether the program has as its object the amelioration of conditions of disadvantaged individuals or groups. Even before the enactment of the Charter, this court in Athabasca Tribal Council and Amoco Canada Petroleum Corporation recognized that ameliorative programs targeting a disadvantaged group do not constitute discrimination. The issue in the case was whether the Energy Resources Conservation Board had jurisdiction to require an affirmative action program for the hiring of Aboriginal people as a condition of its approval of a tar sands plant. The court unanimously concluded that there was no such jurisdiction, but Justice Ritchie, writing for 4 of the judges, Chief Justice Laskin, himself, Justice Dixon, and Justice McIntyre, addressed the affirmative action aspect of the case, concluding that a program designed to benefit the Aboriginal community was not discrimination within the meaning of the Individuals' Rights Protection Act of Alberta. Quote, "In the present case, what is involved is a proposal designed to improve the lot of the Native peoples with a view to enabling them to compete as nearly as possible on equal terms with other members of the community who are seeking employment in the tar sands plant. With all respect, I can see no reason why the measures proposed by the affirmative action programs for the betterment of the lot of the Native peoples in the area in question should be construed as discriminating against other inhabitants. The purpose of the plan, as I understand it, is not to displace non-Indians from their employment, but rather to advance the lot of the Indians so that they may be in a competitive position to obtain employment without regard to the handicaps which their race has inherited." End quote. The Royal Commission report on Equality in Employment whose mandate was to determine whether there should be affirmative action in Canada, and on which Justice McIntyre relied to develop his theories of discrimination and equality, set out the principles underlying Section 15.2 at pages 13 to 14. Quote, "In recognition of the journey many have yet to complete before they achieve equality, and in recognition of how the duration of the journey has been and is being unfairly protracted by arbitrary barriers, Section 15.2 permits laws, programs, or activities designed to eliminate these restraints. While Section 15.1 guarantees to individuals the right to be treated as equals, free from discrimination, Section 15.2, though itself creating no enforceable remedy, assures that it is neither discriminatory nor a violation of the equality guarantee by Section 15.1 to attempt to improve the condition of disadvantaged individuals or groups, even if this means treating them differently. Section 15.2 covers the canvas with a broad brush, permitting a group remedy for discrimination. The section encourages a comprehensive or systemic rather than a particularized approach to the elimination of discriminatory barriers. Section 15.2 does not create the statutory obligation to establish laws, programs, or activities to hasten equality, ameliorate disadvantage, or eliminate discrimination, but it sanctions them, acting with statutory acquiescence." End quote. In essence, Section 15.2 of the Charter seeks to protect efforts by the state to develop and adopt remedial schemes designed to assist disadvantaged groups. This interpretation is confirmed by the language in Section 15.2, quote, "does not preclude," end quote. This court dealt explicitly with the relationship between Section 15.1 and Section 15.2 in Lovelace and Ontario. The court, per Justice Yakabuchi, appeared unwilling at that time to give Section 15.2 independent force, but left the door open for that possibility at paragraph 108. Quote, "At this stage of the jurisprudence, I see Section 15.2 as confirmatory of Section 15.1, and, in that respect, claimants arguing equality claims in the future should first be directed to Section 15.1, since that subsection can embrace ameliorative programs of the kind that are contemplated by Section 15.2. By doing that, one can ensure that the program is subject to the full scrutiny of the discrimination analysis, as well as the possibility of a Section 1 review. However, we may well wish to reconsider this matter at a future time in the context of another case." End quote. Justice Yakabuchi in Lovelace perceived two possible approaches to the interpretation of Section 15.2. He believed that the Supreme Court could either read Section 15.2 as an interpretive aid to Section 15.1, the approach adopted in Lovelace, or read it as an exception or exemption from the operation of Section 15.1. He favored the interpretive aid approach, while acknowledging that the exemption approach had some support. In particular, he cited Mark A. Drumble and John D. R. Craig for the proposition that Section 15.2 should defend against a Section 15.1 violation, because otherwise the provision becomes redundant and does not encourage the government to combat discrimination proactively through ameliorative programs. In our view, there is a third option. If the government can demonstrate that an impugned provision meets the criteria of Section 15.2, it may be unnecessary to conduct a Section 15.1 analysis at all. As discussed at the outset of this analysis, Section 15.1 and Section 15.2 should be read as working together to promote substantive equality. The focus of Section 15.1 is on preventing governments from making distinctions based on enumerated or analogous grounds that have the effect of perpetuating disadvantage or prejudice, or imposing disadvantage on the basis of stereotyping. The focus of Section 15.2 is on enabling governments to proactively combat discrimination. Read thus, the two sections are confirmatory of each other. Section 15.2 supports a full expression of equality, rather than derogating from it. Under a substantive definition of equality, different treatment in the service of equality for disadvantaged groups is an expression of equality, not an exception to it. But this confirmatory purpose does not preclude an independent role for Section 15.2. Section 15.2 is more than a hortatory admonition. It tells us in simple, clear language that Section 15.1 cannot be read in a way that finds an ameliorative program aimed at combating disadvantage to be discriminatory and in breach of Section 15. Here the appellants claim discrimination on the basis of Section 15.1. The source of that discrimination, the very essence of their complaint, is a program that may be ameliorative. This leaves but one conclusion. If the government establishes that the program falls under Section 15.2, the appellant's claim must fail. In other words, once the Section 15 claimant has shown a distinction made on an enumerated or analogous ground, it is open to the government to show that the impugned law, program, or activity is ameliorative and thus constitutional. This approach has the advantage of avoiding the symbolic problem of finding a program discriminatory before saving it as ameliorative, while also giving independent force to a provision that has been written as distinct and separate from Section 15.1. Should the government fail to demonstrate that its program falls under Section 15.2, the program must then receive full scrutiny under Section 15.1 to determine whether its impact is discriminatory. We would therefore formulate the test under Section 15.2 as follows. A program does not violate the Section 15 equality guarantee if the government can demonstrate that 1. The program has an ameliorative or remedial purpose, and 2. The program targets a disadvantaged group identified by the enumerated or analogous grounds. In proposing this test, we are mindful that future cases may demand some adjustment to the framework in order to meet the litigant's particular circumstances. However, at this early stage in the development of the law surrounding Section 15.2, the test we have described provides a basic starting point, one that is adequate for determining the issues before us on this appeal, but leaves open the possibility for future refinement. We build our analysis of Section 15.2 and its operation around 3 key phrases in the provision. The subsection protects, quote, any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, end quote. While there is some overlap in the considerations raised by each of these terms, it may be useful to consider each of them individually. A. Has as its object. In interpreting this phrase, 2 issues arise. The first is whether courts should look to the purpose or to the effect of legislation. The second is whether, in order to qualify for Section 15.2 protection, a program must have an ameliorative purpose as its sole object, or whether having such a goal as one of several objectives is sufficient. The language of Section 15.2 suggests that legislative goal rather than actual effect is the paramount consideration in determining whether or not a program qualifies for Section 15.2 protection. Michael Pierce defends this view, which he refers to as the subjective approach, because it adheres more closely to the language of the provision and avoids potentially inappropriate judicial intervention in government programs. Scholars have nonetheless disagreed about the appropriate approach, often using the subjective goal-based and objective effects-based language. Scholars and judges who have supported judicial examination of the actual effect of a program offer one primary argument to defend their view. They express concern that a subjective test will permit the government to defeat a discrimination claim by declaring that the impugned law has an ameliorative purpose. Thus, Russell Jurian states that a purely subjective test may be too wide. David Lepofsky and Jerome Bickenbach believe that the better view is that the defendant must establish that the impugned program has some serious likelihood of achieving its ameliorative goal. They justify this perspective with the argument that, quote, if ameliorative legislative purpose were the sole test under Section 15.2, a legislature could easily circumvent the egalitarian requirements under Section 15.1 by including in any potentially discriminatory legislation a clause which provides that this act has as its object the amelioration of the conditions of a disadvantaged group, end quote. In our opinion, this concern can be easily addressed. There is nothing to suggest that a test focused on the goal of legislation must slavishly accept the government's characterization of its purpose. Courts could well examine legislation to ensure that the declared purpose is genuine. Courts confronted with a Section 15.2 claim have done just that. For example, in Manitoba Rice Farmers Association and Human Rights Commission of Manitoba, Justice Simonson explained at paragraph 51, quote, "A bald declaration by government that it has adopted a program which has as its object the amelioration of conditions of disadvantaged individuals or groups including those that are disadvantaged because of race, does not, ipso facto, meet the requirements to sanctify the program under Section 15.2 of the Charter. The government cannot employ such a naked declaration as a shield to protect an activity or program which is unnecessarily discriminatory." End quote. In that vein, proponents of the approach that focuses on the ameliorative goal of the program, rather than its effect, argue that doing so will prevent courts from unduly interfering in ameliorative programs created by the legislature. They note that Canadian Charter drafters wish to avoid the American experience, whereby judges overturned affirmative action programs under the banner of equality. The purpose-driven approach also reflects the language of the provision itself, which focuses on the object of the program, law, or activity rather than its impact. Moreover, the effects of a program in its fledgling stages cannot always be easily ascertained. The law or program may be experimental. If the sincere purpose is to promote equality by ameliorating the conditions of a disadvantaged group, the government should be given some leeway to adopt innovative programs, even though some may ultimately prove to be unsuccessful. The government may learn from such failures and revise equality-enhancing programs to make them more effective. Given the language of the provision and its goal of enabling governments to proactively combat discrimination, we believe the purpose-based approach is more appropriate than the effect-based approach, where a law, program, or activity creates a distinction based on an enumerated or analogous ground. Was the government's goal in creating that distinction to improve the conditions of a group that is disadvantaged? In examining purpose, courts may therefore find it necessary to consider not only statements made by the drafters of the program, but also whether the legislature chose means rationally related to that ameliorative purpose, in the sense that it appears at least plausible that the program may indeed advance the stated goal of combating disadvantage. The Manitoba Court of Queen's Bench suggested that it favored an analysis of this kind in Manitoba Rice Farmers Association at paragraph 54. Quote, "In order to justify a program under Section 15.2, I believe there must be a real nexus between the object of the program as declared by the government and its form and implementation. It is not sufficient to declare that the object of a program is to help a disadvantaged group if, in fact, the ameliorative remedy is not directed toward the cause of the disadvantage. There must be a unity or interrelationship amongst the elements in the program which will prompt the court to conclude that the remedy in its form and implementation is rationally related to the cause of the disadvantage." End quote. Analyzing the means employed by the government can easily turn into assessing the effect of the program. As a result, to preserve an intent-based analysis, courts could be encouraged to frame the analysis as follows. Was it rational for the state to conclude that the means chosen to reach its ameliorative goal would contribute to that purpose? For the distinction to be rational, there must be a correlation between the program and the disadvantage suffered by the target group. Such a standard permits significant deference to the legislature, but allows judicial review where a program nominally seeks to serve the disadvantaged, but in practice serves other non-remedial objects. The next issue is whether the program's ameliorative purpose needs to be its exclusive objective. Programs frequently serve more than one purpose or attempt to meet more than one goal. Must the ameliorative object be the sole object, or may it be one of several? We can find little justification for requiring the ameliorative purpose to be the sole object of a program. it seems unlikely that a single purpose will motivate any particular program. Any number of goals are likely to be subsumed within a single scheme. To prevent such programs from earning Section 15.2 protection on the grounds that they contain other objectives seems to undermine the goal of Section 15.2. The importance of the ameliorative purpose within the scheme may help determine the scope of Section 15.2 protection, however. Consider that an ameliorative program may coexist with or interact with a larger legislative scheme. If only the program has an ameliorative purpose, does Section 15.2 extend to protect the wider legislative scheme? We offer as a tentative guide that Section 15.2 precludes from Section 15.1 review distinctions made on enumerated or analogous grounds that serve and are necessary to the ameliorative purpose. B. Amelioration. Section 15.2 protects programs that aim to ameliorate the condition of disadvantaged groups identified by enumerated or analogous grounds. Although the word does not at first seem liable to misunderstanding, courts have previously understood the term in Section 15.2 to apply in surprising circumstances. In the Queen and Music Explosion Limited, the Manitoba Court of Queen's Bench upheld a Winnipeg bylaw that restricted young people under 16 from operating an amusement device without the consent of a guardian or parent on the grounds that it was protected by Section 15.2. Justice Smith declared that the bylaw, quote, is obviously for the benefit of the special needs of young persons, end quote. On appeal, the decision was reversed. The Court of Appeal explained, quote, this legislation does not confer special benefits upon young people, but rather imposes a limitation. Nor is the purpose of the legislation the amelioration of their condition, end quote. Courts have also used Section 15.2 to uphold provisions of the Criminal Code and of the Young Offenders Act. These precedents suggest that the meaning of amelioration deserves careful attention in evaluating programs under Section 15.2. We would suggest that laws designed to restrict or punish behavior would not qualify for Section 15.2 protection. Nor, as already discussed, should the focus be on the effect of the law. This said, the fact that a law has no plausible or predictable ameliorative effect may render suspect the state's ameliorative purpose. Governments, as discussed above, are not permitted to protect discriminatory programs on colorable pretexts. C. Disadvantaged. The interpretation of disadvantaged explored in Andrews, Myron and Trudell, and Law, and other cases in the context of Section 15.1 requires a little further elaboration here. Disadvantage under Section 15 connotes vulnerability, prejudice, and negative social characterization. Section 15.2's purpose is to protect government programs targeting the conditions of a specific and identifiable disadvantaged group, as contrasted with broad societal legislation, such as social assistance programs. Not all members of the group need to be disadvantaged, as long as the group as a whole has experienced discrimination. Subpart 3. Application of Section 15.2 to this case. The appellants have argued they were denied a benefit on the basis of race, a ground enumerated in Section 15 of the Charter. As discussed above, once the appellants have demonstrated such a distinction, the government may attempt to show the program is protected under Section 15.2. The government conferred the communal fishing license, valid for August 19th to 20th, to particular Aboriginal bands. Therefore, we are satisfied the appellants have demonstrated a distinction imposed on the basis of race, an enumerated ground under Section 15. We have earlier suggested that a distinction based on the enumerated or analogous grounds in a government program will not constitute discrimination under Section 15 if, under Section 15.2, 1. The program has an ameliorative or remedial purpose, and 2. The program targets a disadvantaged group identified by the enumerated or analogous grounds. The question is whether the program at issue on this appeal meets these conditions. The first issue is whether the program that excluded Mr. Kapp and other non-banned fishers from the fishery had an ameliorative or remedial purpose. The Crown describes numerous objectives for the impugned pilot sales program. These include negotiating solutions to Aboriginal fishing rights claims, providing economic opportunities to native bands, and supporting their progress towards self-sufficiency. The impugned fishing license relates to all of these goals. The pilot sales program was part of an attempt, albeit a small part, to negotiate a solution to Aboriginal fishing rights claims. The communal fishing license provided economic opportunities through sailor trade to the bands. Through these endeavors, the government was pursuing the goal of promoting band self-sufficiency. In these ways, the government was hoping to redress the social and economic disadvantage of the targeted bands. The means chosen to achieve the purpose, special fishing privileges for Aboriginal communities constituting a benefit, are rationally related to serving that purpose. It follows that the Crown has established a credible ameliorative purpose for the program. The government's aims correlate to the actual economic and social disadvantage suffered by band members of the 3 Aboriginal bands. The disadvantage of Aboriginal people is indisputable. In Corbier in Canada, Minister of Indian and Northern Affairs, the court noted, quote, the legacy of stereotyping and prejudice against Aboriginal peoples, end quote. The court has also acknowledged that, quote, Aboriginal peoples experience high rates of unemployment and poverty and face serious disadvantages in the areas of education, health, and housing, end quote. More particularly, the evidence shows in this case that the bands granted the benefit were in fact disadvantaged in terms of income, education, and a host of other measures. This disadvantage, rooted in history, continues to this day. The communal fishing license, by addressing long-term goals of self-sufficiency and, more importantly, by providing additional sources of income and employment, relates to the social and economic disadvantage suffered by the bands. The fact that some individual members of the bands may not experience personal disadvantage does not negate the group disadvantage suffered by band members. Mr. Kapp suggests that the focus must be on the particular forms of disadvantage suffered by the bands who received the benefit, and argues that this program did not offer a benefit that effectively tackled the problems faced by these bands. As discussed above, what is required is a correlation between the program and the disadvantage suffered by the target group. If the target group is socially and economically disadvantaged, as is the case here, and the program may rationally address that disadvantage, then the necessary correspondence is established. We conclude that the government program here at issue is protected by Section 15.2 as a program that has as its object the amelioration of conditions of disadvantaged individuals or groups. It follows that the program does not violate the equality guarantee of Section 15 of the Charter. Part 4. Section 25 of the Charter. Having concluded that a breach of Section 15 is not established, it is unnecessary to consider whether Section 25 of the Charter would bar the appellant's claim. However, we wish to signal our concerns with aspects of the reasoning of Justice Bastarache and of Appeal Justice Kirkpatrick, both of whom would have dismissed the appeal solely on the basis of Section 25. An initial concern is whether the communal fishing license at issue in this case lies within Section 25's compass. In our view, the wording of Section 25 and the examples given therein, Aboriginal rights, treaty rights, and other rights or freedoms, such as rights derived from the Royal Proclamation or from land claim agreements, suggest that not every Aboriginal interest or program falls within the provision's scope. Rather, only rights of a constitutional character are likely to benefit from Section 25. If so, we would question, without deciding, whether the fishing license is a Section 25 right or freedom. A second concern is whether, even if the fishing license does fall under Section 25, the result would constitute an absolute bar to the appellant's Section 15 claim, as distinguished from an interpretive provision informing the construction of potentially conflicting charter rights. These issues raise complex questions of the utmost importance to the peaceful reconciliation of Aboriginal entitlements with the interests of all Canadians. In our view, prudence suggests that these issues are best left for resolution on a case-by-case basis as they arise before the court. Part D. Conclusion. We would dismiss the appeal on the ground that a breach of the Section 15 equality guarantee has not been established.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zack Battiston and Carly Lyons. It is hosted by Zack Battiston, Carly Lyons, and you, our listeners. Executive produced by Zack Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.